Thanks everyone for joining us. We are live here as well as on YouTube. Our YouTube viewers are about 15 seconds delayed. That's just kind of the way the technology works. But we are watching chat in both spaces. So feel free to chime in with questions for our presenters at any time. We're here today to talk about the diploma privilege with our guests, Blair and Hannah. Why don't we start just with a quick set of introductions. Blair, why don't you tell us a little bit about yourself?
Yeah. Hi, good morning, everyone. I'm Blair Harrington, and I'm the current new lawyer section chair of the new lawyer section of the MSBA. And I am an employment law attorney at Taft Law, doing a mix of employment advising and also employment litigation.
Welcome, Blair. And Hannah?
And I'm Hannah Scheidecker. I'm currently a third-year law student at Mitchell Hamline and hope to be graduating in 10 days.
Welcome. Thanks for joining us. I want to start just with an overview of kind of what's at stake in this discussion. We should probably start with an overview of what's going on with the diploma privilege. I did bring up the administrative order here, so there has been some action. I'll leave this open to either Blair or Hannah who wants to tell us a little bit about what this is about. Why are we talking about the diploma privilege right now? Let's start with Hannah. Sorry.
Yeah, start with Hannah.
We'll give Hannah the start.
Okay. Well, everything has changed drastically in the last couple months, and so for a lot of us who are graduating and either have employment lined up or don't, we're concerned that our health is going to be put at risk, and that those around us are also going to be put at risk because of us having to actually sit and take the bar exam kind of in the uncertain times. I think that another big concern for us is the uncertainty around everything, just that the exam could be determined to go on at the May 15th board meeting, and then the week before it could be canceled. Just with us, I think mental health wise and financially, we're not able to handle going through studying twice. And so the petition is looking to amend the student practice rules. So the Minnesota Board of Law Examiners submitted an amendment to the student practice rules discussing the ability for student practice under supervision with an attorney. And I do think that it could be amended a little bit further, which I think we were going to talk about here today, but that's just kind of a brief overview of what we're hoping for, diploma privilege, or at least some sort of modified version of it for the sake of everyone's health and safety.
And I think your letter also said, so what we're talking about here is the ability for someone who hasn't taken the bar exam, but has graduated from law school or is a student to practice law under the supervision of an admitted attorney. And I think your letter also that you put into the law student community, and we're getting some signatories for, talked about, what's the big deal? I guess I'll pose it as a question. What's the big deal about having to wait 6 months to take the bar exam if it's postponed to, say, September?
Right. So I guess I think of all of the amount of debt that most law students have, and how that's going to be kicking in right when we're supposed to be potentially taking a September exam if it were postponed. And also the fact that, after graduation, a lot of us have employers that are waiting and expecting for us to be able to start sometime in October after the results are in, and it's just sort of not a feasible option that we would have to wait even further or ask them to be okay with waiting further. And it also sort of goes to disadvantage anybody who's looking to do solo practice or public interest practice, because there is often not any resources for people to be supervised because, resources are already so limited that it'd be a lot to ask of employers to be able to provide a position or ask them to take on more on their caseload.
And there is quite a bit of uncertainty. This is just the map from the National Conference of Bar Examiners of states which have or have not postponed the bar exam. I looked at the bar examiner's website, and it is shocking to see. It was sort of, we'll let you know when we know.
I also noticed that they don't they don't have Wisconsin down for the diploma privileges, which is what I think Wisconsin is known for, but that's only for Wisconsin schools.
That's right. That's right.
It's also,
I did hear that New York was doing something similar with diploma privileges, but only for those that graduate from a New York school.
Well, New York and Massachusetts, I think, are only seating folks for the bar exam who, or the preferences for folks who graduated from a law school from that state. And I think some of the links in this week's Legal News Digest are about the folks who are saying, you know, why aren't we just, I'll maybe pose this question to the group too, why aren't we just doing an online bar exam? Do we really need to be seated, even if it's 6 feet apart, to take the bar exam? It's maybe a separate issue, but I think that's some of the frustration that I've been reading about over, you know, the big deal that people are making about New York's and Massachusetts' preference for local law students.
I think that one of the biggest frustrations for me as a student is all of the runaround that we're getting from everyone, because we have the NCBE who is waiting on, basically issued their statement yesterday, which is, you know, saying that we think there's going to be enough jurisdictions that are going to take this. So we're going to provide the material, which once again, very uncertain, because there are still, as they acknowledge, many states that haven't yet decided whether the test is going to be able to be administered. So we're going to find out whether Minnesota will hold the exam right about when we're supposed to start studying. And so I think another frustrating part of this is that we are getting the NCBE telling us that we need to, or that they're going to provide it, which kind of, I think, pushes the states to hold the exam if they're going to provide the material. So I think we're kind of waiting on, we're kind of pointing fingers at each other, waiting for people to actually take action. And the NCBE has said that they're making sure that we get this done quickly so that students have their answers, which I really think is ironic, since all of this is non-definitive answers that we're getting.
And creating more ambiguity. Interesting. So let's chat about the order. I want to just kind of give an outline of what it offers and where it might not go far enough. I know that Blair, I know the new lawyers section was in support of this to a certain degree, but maybe not thinking this went far enough.
Yeah, so just to give a little background, this came up in a meeting a few weeks ago before the petition had been submitted at one of our monthly section meetings. Someone on our council raised it, and there was a discussion that we had about, you know, the effect this would have on law students and recent graduates, and then also people who are planning to retake the bar exam and people who are licensed in other jurisdictions who want to become licensed in Minnesota. And so we're kind of the section of the bar that's, you know, we're the new lawyer section, so we're closest in time. We have a lot of law school students who are members of our section. And so we wanted to take on a position because we know that nothing really had been done and that there was this gap in ability to practice under supervision under the rules. So then from there, we started drafting our own position statement, which we have finalized and will be discussed this week at the MSBA council meeting. So it's not publicly distributed right now, but we hope it will be soon, or at least get approval to be a section only position. So I also have spoken with Emily Eschweiler, who I saw was on this call, spoke with her kind of right before the board filed their petition, but after our section had a discussion just to kind of talk about what their plans were. And obviously we support an amendment to the rules so that graduates can go back and get this limited licensure to practice in the event the bar exam does not move forward with, and we don't know if it is or not at this point, which Hannah has discussed is really frustrating. And even looking at the date, like I know most people started studying for the bar a week after graduating, which is next week. So just for planning purposes, I can't imagine how frustrating and uncertain this time is as a student that's graduating.
Are the Barbary and the Themis, the bar review courses, are those still happening?
Yes, our bar review courses email us with updates on what's going on nationally. I think I saw somewhere, correct me if I'm wrong, but I believe Emily Eschweiler touched on it a little bit. I think Barbary may have been also offering a refund if it were canceled, or some sort of delay, offering that the course would be extended past the time should the exam not happen in July. So they've been really good about working with students on setting their schedules.
So tell us about where, I think we talked about who sort of falls within the scope of the proposed rule. Blair, I think you mentioned in a separate conversation folks who may be second-time test takers or out-of-state practitioners. The current proposed rule does not include those folks?
Correct. I believe it only includes recent graduates in the past year who are seeking to take this next July bar. So anyone who has failed a prior bar is excluded based on how the rule is written. And then it also does not include people who would be, who have been licensed for a while in another jurisdiction but are seeking to get admitted in Minnesota. And there's already a lot of stigma and financial issues with someone who has failed the bar exam. But once you do pass the bar exam, you can practice and are treated just like everyone else. So I know we have some of our members who have taken the exam multiple times and are currently licensed now and feel strongly that this group should be included. I mean, otherwise they're just out for however long this goes on until without being able to practice with the supervised licensed, and then that limits their job prospects and what they can actually do during this period until they are finally able to take and pass the exam.
And you expect that'll be probably the position of the NLS council as well?
Yeah, that is definitely the position of the council. And then the council is also encouraging the board to administer an online exam.
Oh, interesting.
Yeah, so I know that when I spoke with Emily, that she said that a lot of that was up to the NCBE, which we understand, but I have seen states in the past couple weeks say that they were planning to do online administration. I think California and Massachusetts were talking about that, regardless of the NCBE, it coming from the NCBE. So I think that would be an important thing to consider here, just for everyone's safety, and because obviously everyone's gone online now for law school examinations. Even when I was in law school, we did everything through an ExamSoft software, and that's how the essays on the bar were anyway. So moving multiple choice to an online format shouldn't be too difficult. But again, not intimately involved with that. It just I think we've seen a huge shift in the past 2 months with everything being switched to being online, and there's still a couple months to get that ironed out for a July examination. So we are encouraging the board to consider that as an option.
I've also emailed Emily a handful of times, and I feel bad because I think I've emailed her probably 15 times now in the last month, voicing concerns, sharing articles of potential ideas. I understand that asking for diploma privilege is a very big step and something that's pretty unprecedented. So I've sort of been thinking of other creative solutions too. And so when Massachusetts came out with their saying, you know, we don't really care what the NCBE is going to do. We're going to administer our own online exam. And then these people will just be licensed for the state of Massachusetts until it's safe for them to actually take an exam. So I think something like that would be very forward thinking. And the NCBE keeps saying, we're working on the technology to do an online exam, but when we did our town hall with Emily as well, there was a question of integrity and cheating online. And to me, that is kind of a moot point if we're already going to be going through a character and fitness evaluation and hopefully going into a profession that if we're expected to show up not sick to take an exam, we would also be expected to show up and not cheat in an online format. So I guess I think the integrity side of it as well. I mean, even doing some practice questions for the bar practice class that I'm in, you have no time to cheat, even if you wanted to, with the way that the format of the exam is. So I just think that that would be definitely a good move going forward.
I know some of those tools, ExamSoft included, have, and I'm not sure kind of what the quality of these tools are, but automated proctoring tools examine your eye movement and things like that. A little creepy, but quite sophisticated now as well.
Yeah, ExamSoft crashes a lot for us here at Mitchell Hamline, so that's kind of a soft subject. But
oh, does it really?
We've had a few, you know, your exam is not uploaded type of things. But yeah, that would definitely be probably the best option though moving forward if that were to be considered.
So
I have heard plenty of people commenting that that one of the concerns and one of the pushbacks for not granting diploma privileges is then the slippery slope argument, or at least they propose it that it's the slippery slope argument that, well, if we give them diploma privileges this year and we don't require them to take the test, why do we ever require anybody to take the test? They're going to argue that we should get rid of the test. I mean, it's the argument that gets thrown out there, but at the same time, even without COVID, there's plenty of people that say, no, we shouldn't have the test, or yes, the test is necessary. What are your thoughts on everybody making the slippery slope argument?
I'm with Carr in the chat on this one. Would it be so bad? Because we get the pushback. A friend of mine who said, I just can't get behind this. I asked what her argument was, and she said, well, the people deserve a competent attorney, but the bar exam doesn't test competence. It tests your ability to memorize 14 subjects and regurgitate it. If it did test competence, then any practicing attorney would be required to retake it every so often to test their competence in practice. Because I don't know. I mean, maybe this is just me being on the negative side of things, but I just don't think that it's realistic that we expect that an exam that, you know, people who don't have the opportunity to study because of familial obligations, caregiver obligations, no childcare, are going to be especially disadvantaged. Or that, I mean, we've had students in our class have to go sit in the parking lot of Caribou right away because they didn't have internet access at home to submit an assignment.
And of course, to play devil's advocate on this, you know, you could go through and say, well, testing competency, this is the best way we've found is to force people to memorize up to 14 subjects and regurgitate the information they have. That's how we test competence. So, yeah, I mean, I absolutely agree. For one thing, the bar exam, unfortunately, doesn't test Minnesota law. So it's a challenge there. But, you know, I guess the question is then, as we're going through this, you know, how do we approach that argument in a way that still convinces the court that diploma privileges would be acceptable and that we won't go down that slippery slope. Any thoughts on that?
Well, with the diploma privilege, you have to have a supervised licensed attorney, which I think creates a huge disadvantage for someone who wants to open a solo practice. That's kind of another issue that I think is not addressed with this rule. And honestly, our section has not discussed, but has been raised by other council members. So you're not the one signing the pleadings with this limited license act, out on your own, acting like you're the licensed attorney on the file. You are being supervised. So I think there's some protective measures and backup check put in place with how this is structured.
And of course, that's, I mean, what I believe Hannah is addressing is trying to expand that even further. Correct me if I'm wrong, Hannah, but saying, hey, let's get rid of essentially the supervision aspect of this and just go straight with the diploma privilege. I think when we take that extra step, that might be the challenge to convince people we're going to take this extra step, let people actually do representation on their own and be confident in their ability. I mean, how do you essentially ensure that there's competency, assuming that we ensure competency now?
Right. I think that having the supervising attorney isn't a bad idea. So I do think it would disadvantage people that are looking to do solo practice, or maybe are at a firm that don't have the resources to do it. However, if we think about it practically, most times when you start working somewhere, they don't just throw you out there. They have you start by observing how they run things in their specific firm, or how certain people maybe write things, or someone maybe reads over your work before you are doing things, just in terms of making sure that everything is the same at the firm and that we're all doing the same kind of work. So I guess I kind of think that as a new attorney, you're almost supervised anyway without being said that you're supervised, sort of. So I guess I don't know. I think that if we had to, if we were arguing about how to maintain competency, and you had, let's say, online tests for certain subjects that you want to practice, or a written note from your superior or supervisor saying this is what they are doing and they're doing it well enough, or I think that might be something that could be feasible as well.
Well,
go ahead.
I was just going to say, as far as competence, I think being able to take the LSAT, get into law school, and graduate from law school is enough to prove your competence as an attorney. The bar exam is just, like Hannah said, memorizing subjects. I probably don't remember half the stuff I jammed into my head for those 2 days, and then you walk out and hope you passed, but it has no correlation to the practice of law.
And I know plenty of people that have been multiple time or like second time test takers that are now practicing attorneys that are just as competent, if not, some of the people that are admitted on the first bar exam are then disbarred later. So I think that's another argument too, that we talk about that, and then there's, like Blair said, there's such a stigma around those that fail the first time, but this is a very high stakes exam, and we even see a decrease in scores in the this past February exam, which to me goes to show COVID being in play there too, which is another reason I think the student practice rules should be amended further, especially for that group of people. For currently, like Blair mentioned, it's anybody graduated in the last 18 months that hasn't taken the bar exam. But I definitely think that the February people that that maybe didn't pass this time around, or even previously, should be allowed to be included as well.
So
I also have an issue. I was just going to say, I also have an issue with the fact that we could be unpaid for up to however long this is,
Right.
because we are going to have JDs. So even jobs that are JD preferred are a higher salary than not. And so the fact that we could be treated, granted, it's up to our employer, but we could, during these hard financial times, be treated as unpaid interns. Also kind of rubs me the wrong way.
One thing I want to throw in a plug. So Dan Willing is in the chat and has, of course, thrown up the question. I'm going to scroll up and read his questions real quick here. So his questions were: does the bar exam improve attorney competence? Question, great question. Does it have any correlation to the capable practice of law in Minnesota? And I will give just a quick plug. I believe the HCBA New Lawyers section, which Dan is the chair of, is planning meeting tomorrow at noon to discuss these topics as well. I think we might have addressed those questions, but other thoughts on that?
I was going to tag on to that question, actually, whether or not, I mean, we were just talking before we started about the fact we all took clinical coursework. So for us, you know, there was that additional learning, but you can still graduate from law school right now, can't you, without any form of clinical coursework?
Correct.
Yeah.
I think that's part of the issue. I know Emily brought up that part of the issue is that Wisconsin, who does diploma privilege, has a very rigorous set out schedule of courses that the people are supposed to take and have to take it with a certain, or, you know, receive a certain grade when taking it. However, I think that granted, for the bar exam, we have to take all these courses. Like, I will never do anything with torts in my life, but I had to take that class. So, I mean, that's great and everything, but how am I going to use that? So, I mean, I understand the application that there are certain rigorous programs put in place. Also ironic that the person that's saying that the bar exam is necessary is the person that didn't take it, because they're the NCBE president and we're licensed via diploma privilege. But that's another point.
There are also a bunch. Oh, go ahead, Landon.
That's a harsh point there. There's talk in the comment section about apprenticeship programs and kind of going that direction. And Karen Ciano, of course, says that there's a lot of writing in regards to history of the bar exam and its predecessor, which is the apprenticeship program. Thoughts on that?
Often disparaged as the Kim Kardashian path right now, right? Because California is one of the few states. I forget what it's called. Isn't it it's a separate path, though. You don't have to graduate through an ABA accredited law school.
Right. She can, I don't know, she's doing some sort of apprenticeship, is my understanding, then taking a limited number of courses and that's required in order to study and take the bar exam.
I think that the idea of an apprenticeship is a great feasible way. I know most people that I'm graduating with or that I go to school with already have done some sort of work. So while it's not required to have an apprenticeship or clinical work, many people do have clinical work experience during their law school time. So we have a lot of volunteers in the self-help clinic that are there and learning how to work with clients. And so I think if they could apply those skills in a real setting with an attorney afterwards, that they'd be able to apply that. And I think also too, I mean, I'm sure you guys can chime in on your own experiences too, but personally, I think that learning hands-on and being in the actual workplace doing things is a much better way to learn than trying to study it on paper.
So Jerry actually brings up a good question here that we haven't talked about, which is stigma, and discussing the idea that diploma privileges for those that graduate in 2020 and essentially skip the bar, which I've heard referred to as the hazing ritual for lawyers. You know, you're essentially skipping out on that, which makes you kind of an offset, somebody that didn't take the bar exam like everybody else. Is there thought behind that stigma? Is there concern about having that stigma for being the class that didn't take the bar?
From what I have heard, no, because everyone is so much more worried about getting sick or getting their family sick that I think that we're trying to put, I do think that's a valid point that we would be looked at, maybe, well, especially by attorneys that have been practicing longer. I found a lot more pushback when trying to get support for my letter. And so I think that it's a lot harder to be, I mean, when we're graduating, we're very ripe, I'm sure anyways, as attorneys. So I'm sure that there's a little bit of hesitancy to just let us jump right in. But I think that another good solution that would address Jerry's question is allowing us to be licensed until it's safe enough to administer a bar exam without needing social distancing or temperature checks or masks and things like that, which would be, I mean, under supervision, but that would be, I think, an appropriate remedy as well.
I took a quick break to look up a quote from Richard Posner's book that I can't believe I found it. Overcoming Law. It's written in the 90s, I think. But he says as late, so this is in response to the questions about the history. As late as 1951, he says 20% of American lawyers had not graduated from law school and 50% had not graduated from college. And he's citing for that 1973 Law Review article. Interesting.
Yeah, so it's not something that, I mean, it hasn't even been around for roughly 100 years.
Jerry just mentioned that she thinks the stigma would be an issue for higher end positions, attorney general attorneys. I know that another thing that some people were considering was having the option for employers to say, we're going to give preferential treatment to those who have taken and passed the bar. So the idea would be that you'd still be able to practice law, but maybe not at that place until you've passed the bar. So the idea is you can practice somewhere else or practice on your own. And then, in a year down the road, when it's safer to take the exam, then they could take the exam.
I mean, some of the other challenges, of course, if we're just talking that you have essentially diploma privileges with supervision, then I think that gives the incentive to eventually take the bar exam. But if we do switch over and it's strictly diploma privileges, you have individuals that may want to work in Wisconsin or work in North Dakota or Florida or somewhere else. And then it's the question of how do you transfer? Obviously, individuals that are in California that go through their program that don't go through an ABA accredited law school have challenges transferring to other states. So I think that's something else that we need to consider going forward.
I'm just bringing up. Oh, sorry, I've just got a quick side note. I'm bringing up Rule 5 here for a question from Kristen about what supervision really means. I'll let you go, Hannah, there, but if anybody wants to comment on the meaning of supervision or whether or not it's detailed enough here, feel free to chime in on that as well.
Yeah, we in the student practice rules too, it sets out the qualifications of what you have to be a supervising attorney, and basically you have to take all responsibility for your student practice attorney, I don't know, your student. And so basically it's kind of like a glorified babysitter position. You get to take all responsibility for them. You are in good standing with the Minnesota Bar Association. And that's pretty much it. There are several points, but you just pretty much have to be in good standing and make sure that they are complying with the rules of professional responsibility and whatnot.
Yeah, so when I was in law school, I was in a housing clinic, and then I also clerked at a law firm. So I was supervised in both of those capacities. And I don't find it too different from how you operate as associate your first couple years of practice. Your work's being checked by a partner or a more senior associate. You can't sign your own pleadings. I feel like that's the biggest difference, and you can't appear on your own in court. You have to have that supervised attorney there. But as far as how things operate at a law firm in terms of drafting and research and writing, I mean, an associate, a licensed associate is doing that, and then having a more senior or partner approve that work anyways. So I don't think it is too different, other than you are not your own like licensed entity on your own.
I do think that the fact that some places have stopped hiring at this time just because of financial reasons and not having enough work really goes to Dan's point in the comments. He says, I have serious concerns with the supervising attorney component given the current environment. He also mentions the limit in hiring, and then this is going to disproportionately impact minority and first generation attorneys. There's already been some people that have argued for that as well. And there was a great letter from a student from the University of Minnesota that really touched on how this is going to disproportionately affect those with health concerns and familial obligations like caregiving and people that are minorities and also don't have those connections that everyone else does or that others may have.
And to that, when we're talking about places that are still hiring, and right now all the courts are of course shut down, so we don't have court appearances and things like that going. But I could see law firms that are hiring individuals for more of a litigation practice, public defender's office, private attorneys, private criminal defense attorneys, places like that. One of the reasons that they typically bring on new associates is to make those first appearance or omnibus hearings or hearings that typically there's not a whole lot that's going to be going on, but you want to try to negotiate it. Work with the new attorneys to be able to do that. From going through the obligations for a supervising lawyer, that's not something they're going to be able to do. I mean, if we look at point number 4 there, the attorney's going to need to be there to go through and, Rule 5.4, subdivision. The attorney's going to need to be there at the hearing to say, yeah, make sure that this person's a student certified, or well, a supervised attorney. I don't know if we're coming up with a new phrase for this. But that really defeats the point of a lot of litigation practices bringing in a new associate to handle, especially in criminal law.
I will say that at the end of that provision, it says, or supervised practitioner is prepared to proceed alone. So if they were making a determination that that person could proceed, because I see a lot of this where all of our law clerk student or friends of mine, they just get tossed in for all like the bail and whatever, the bail lists every day and lockups and stuff. And they just, sometimes their attorney is not in the courtroom with them. They just kind of go in there and do their thing. So I'm wondering if that would be more like maybe after the first or second time, or, that they'd be able to do that on their own. However, I do agree that with already being overworked and underpaid, they've wanted to take on as a public defender, people to supervise officially and to be professionally responsible for them. It isn't just something that you can just say like, oh, they can do it on their own. You have to actually be monitoring their work and seeing what they're doing, because you could be held liable for that.
Yeah,
Go
ahead.
I was just going to say, I think that has to happen anyways when you're a new associate. So again, I don't think that would be like too far outside the bounds of what organically occurs anyways when you're newly licensed.
Well, except for the solo smalls that start out right out of the gate.
Yeah.
And the entire time we've been kind of going through this and preparing for this, I've been trying to figure out a way that somebody could essentially, if they had plans already to open up their own shop, that's what they were going to do. I know people from day one of law school that's their plan. That's how they were going to work. That's what they were, and so they've been working towards that plan. Under these rules, I think it's really difficult to do that. You'd almost have to have, if you're going to open your own law firm, you'd have to open your own law firm as under somebody else's law firm, and essentially have your own practice where they're supervising all of your work, signing off on everything. You'd have to have specially crafted retainer agreements indicating that it's not just you, it's actually somebody else. I don't even know if you could open your own law firm.
Yeah. The way it's currently written, I think you're out of luck until you're licensed.
Yeah.
It's funny that you bring this up because this is actually what I'm going to be doing after graduation. So I am going to be taking over someone's law firm because he's retiring. So I just told him, I didn't even think of this until afterwards. And then I said, well, I guess if the bar exam's postponed, you're not retiring yet. So, because I can't do anything for you. And so we're going to keep in close contact there. But I mean, yeah, you're pretty much going to have to either take over someone's firm or just, you know, beg someone, hey, can I hang out here for a little bit until, you know, I can actually be a licensed attorney and just help you out. Yeah.
So Caranciano, of course, who always has some great wisdom for us, mentioned that, you know, CCLI is working on ways to hook people up with mentors who can supervise. So that's a nice little plug there.
I don't think an entity could be the supervising attorney because they have to be in good standing with the bar. So I think it has to be an actual person, to answer Dan's question in the chat.
Yeah, so it'd probably be one of the attorneys or a couple of the attorneys at a place like BLN or I guess I don't know how that would work if they are taking over. They're the supervising attorney, so it'd be an individual volunteering at that organization that would offer to be the mentor, but they would still have to have 100% access to all of the case file, all of the case information, sign off on all the pleadings. I think that's a challenge that I think a lot of volunteers would be hard pressed to take on.
Yeah, I agree.
We were told that Minnesota wasn't even considering diploma privilege. So I found that a little bit disheartening. I mean, it's a very big thing to ask for, but the fact that it wasn't even being considered or isn't being considered. So that's why I did email Emily 15 times because I was just trying to provide the board, because any correspondence submitted to the board by the May 4th, would be provided to them at their board meeting. So that's when I sent the letter with all the signatures on it, and sent several articles about, there were several the U of M, one U of M professor chimed in on it, but it was a joint paper talking about COVID and how this is affecting attorneys and everything. But yeah, I think one of the irritating things is that they weren't even considering it. So now it seems like as an entity, they're trying to move forward with the bar exam because that's what they're supposed to do. They're supposed to administer an exam. But I think that leaves a lot of empty planning for alternatives to the exam if we find out that we all of a sudden just can't take it. I think there needs to be the option that if we find out the week prior that we're not going to be able to take the exam, that an online exam should be our backup plan to still take during that time period.
I think the board was planning to make a decision by May 15th or sometime in the next few weeks.
Yep, they're meeting on the 15th. I'm going to go to it or appear or whatever. I don't know. It's open to the public. And then they said they'll give us an answer by May 18th.
Okay.
Yeah. And comments on this rule are, and I've never done this before, but they are made here, correct? for comments on the rule, if you want to submit. And those are due, what, I think May 22nd?
Yeah, I think it's in the order somewhere. I don't remember exactly.
Sorry for the scrolling. I don't mean to make everyone dizzy. Yeah, April, no, I'm sorry.
I think it's 1 month of comments.
Yeah.
Yeah.
Yeah. All right, great. And I always forget to warn folks that we always go long on these conversations. My apologies. I will drop in the event code for today's CLE credit. Thanks everyone for joining us. I also want to say thank you to Emily Eschweiler, who joined us. Emily, feel free to chat me privately if there's anything we need to follow up or any comments you want to send to this group. I've got everyone's email, so if there's any follow-up we need to do or any comments you'd like to make, feel free to forward those to me. I should wrap us up though. Any parting thoughts from our panelists?
I just want to say thank you to all of you for your advocacy in this. It's nice to have other attorneys understanding a little bit where we're coming from as new graduates. So I appreciate your willingness, and the people in the chat that I've chatted with as well, willingness to be receptive to change.
Yeah, I mean, that's one of the great things that I like about the bar associations is, you know, people with a voice, people that want to get things done, that see a reason for change. You know, the bar association is a great place to get that motivation and to get that going. So, yeah.
Yeah, and we're happy to help support the recent graduates and other people who are planning to take the exam this July.
Wonderful. Thank you both for joining us. This was a great conversation. I really appreciate it. We'll be online next week with Thomas Hamilton of Ross Intelligence. Ross Intelligence is one of our new Advantage partners. They're a legal research platform, strictly speaking, a competitor with Fastcase. But Fastcase and Ross have recently partnered to develop some new tools, and Ross is sort of on the forefront of artificial intelligence and how lawyers are using AI for a whole broad range of legal tasks. So we'll be talking to Thomas about that next week. Please join us then. In the meantime, everyone have, how many credits, Ronald? It's 1/2 credit. That's why we call them bite-sized CLEs. We offer a half credit free every Wednesday morning. So join us next Wednesday morning. And again, you guys, thank you so much. I really appreciate you joining us so early. This was a great conversation. Everyone have a really great week.